Call the member for Maitland and Shadow Minister.
Thank you, Mr Temporary Speaker. I rise to speak on the Justice Legislation Amendment Bill number 3, cognate bills. And I say at the start that these 3 cognate bills were second read by the Attorney-General. They are part of a trend that we seem to be seeing by the government of putting bills which would normally be presented as standalone bills together to be debated in a cognate way, which I fear, particularly in relation to my portfolios of prevention of domestic violence and sexual assault, and also the acting portfolio of women, make it difficult for these changes, which will have a significant impact on those people, to be considered in an appropriate way, and to have that airing and ventilation that should happen in these kind of debates. And it really makes me question the legislative capacity of the government, that things are having to be dealt with in this way. So in the limited time I have available to me, I would like to point out and to highlight some of the issues in relevance to my portfolios. I'll start with the extension of the circumstances of an aggravated sexual assault, and under this legislation and this amendment, sexual assault will also be treated as an aggravated sexual assault if the alleged offender threatens to inflict grievous bodily harm or wound the alleged victim or any other person who is present or nearby at the time of or immediately after or before the commission of an offence of sexual assault, whether or not by means of an offensive weapon or instrument. And a review of the New South Wales Criminal Court statistics establishes how difficult it is to get a conviction for this offence. For example, in 2017, of almost 6,000 charges finalised, only 2,500 or 42% were proven. And of the 1,576 defendants with a finalised charge of 875 or 55% had their charge proven by the courts. So there is a lot riding on this amendment in terms of community deterrence, so that the extension of the alleged offence will also include threatening those witnesses. So that is a positive step. I also note the update in language for the offence of intimidation by replacing gender-specific language and extending the provision to include intimidation of a person's de facto partner, where currently the offence extends to the intimidation of a person's spouse only. And I return to my earlier comments about the impact of these pieces of legislation. We saw earlier in the term of this government, or the most recent term of this government, changes to ADVOs and to make them in plain English, because we know that perpetrators, for example, in the domestic violence space, pointing to their lack of understanding of the rules for breaches. If we're going to make changes like this, which will have an impact on the way that legislation impacts on survivors of sexual assault and perpetrators and other issues, we need to make sure that they are actually being communicated properly, and part of that communication process must surely be in an in-depth discussion about those issues, rather than just ramming them through the House as a cognate bill. Another important aspect of this bill is additional protection for survivors of domestic violence by ensuring that the sharing of information under an information sharing arrangement doesn't prevent a claim of sexual assault communications privilege in relation to that information. The Criminal Procedure Act of 1986 provides for the sexual assault communications privilege scheme, and this scheme protects the counselling records of sexual assault complainants from being compelled to be produced, including by subpoena or on behalf of a defendant, and adduced in criminal proceedings without the leave of the court. And this is a very important protection for sexual assault complainants. In fact, it was an issue that I discussed at some length with the Attorney-General in meetings I held with him last year, and also with the Minister for the Prevention of Domestic Violence and Sexual Assault, in regards particularly to the disastrous privatisation and competitive tender process for the 1800 Respect sexual assault counselling service. And this was something that was very much raised by survivors and also the services involved in that, and I pay tribute to Karen Willis of Rape Domestic Violence Services Australia for the work that she's done here to advocate for that. The amendment ensures that the disclosure of a protected confidence for the purposes of Part 13A of the Crimes, Domestic and Personal Violence Act will not result in the loss of sexual assault communications privilege that attaches to the protected confidence. Part 13A allows for information sharing between government and non-government agencies in cases of domestic violence. The information sharing arrangements assist to facilitate access for victims and survivors of domestic violence to support services and help to reduce or prevent serious threats to the life, health or safety of the victim. And information shared in accordance with Part 13A, for example, includes in the course of developing a safety action plan for a victim relevantly may include information provided to a counsellor in relation to sexual assault. And this is again something that, this whole area of 13A is something that has been a real issue for the legislation for those working in the sector, particularly with the changes to the model of dealing with domestic violence, about working out the difference between confidentiality of information, privilege around information and privacy. And I think it's something that we would all do well to be aware of as well, because I know that has had some current issues there, which I won't go into. The bill includes clarifying provisions for particularly for survivors of domestic violence and sexual assault about phone numbers and addresses and subpoenaed material, and about how they can be released or not. And I think, again, this is something we have to be very careful here. We've seen some terrible breaches of personal information, which has put victims and survivors of domestic violence particularly at grave risk. In fact, I remember being in this very place when I received information that an address had been left on of a victim or a survivor of domestic violence, and it had been released by police, and her perpetrator had been released from jail, and it was a very scary time for that person, knowing that their personal address details were out there. So we need to be very careful about those sorts of things. I want to discuss the proposed victim impact statements, and I take this opportunity to acknowledge the work of the Sentencing Council here. Survivors and victims and their families should be heard as part of the sentencing procedures, and I support the proposition in this bill that victims be allowed to explain to the court the full extent of the suffering that they have experienced. Part of the violation of sexual assault and crimes in general is often the secrecy, the shame that they have experienced. So under the proposed new Section 28, a victim impact statement by a primary victim will be able to discuss any of the following harms suffered by the victim or their immediate family as a direct result of the offence, including physical, psychological, psychiatric harm, emotional suffering, distress, harm to relationships and economic loss that arises from these above forms of harm. And I think that this is really important because we see the horror that is attached to discussions around sexual assault, sexual harassment, violence in any forum, but part of the empowerment for those who experience this is to tell their story. It's not just about telling it for the court to take consideration in sentencing. I think there's also an incredibly empowering aspect of that. You know, it's something that I've been working with many activists around changing laws in Tasmania and Northern Territory around sexual assault victims. In fact, in those states, victims are precluded at this stage from identifying themselves, even if their perpetrator has been identified. Now, while that could have been seen in previous times to be of some protection because of the process of shame that goes or has traditionally been placed on survivors of assaults, I think it's well past time that all states move past that, and so I pay tribute particularly to Nina Fennell for pushing that campaign of #LetHerSpeak. And I think it's important to note that it's let the person who is the victim speak of their issues. I also want to support extending the ranges of offences to which victims are entitled to make a victim impact statement, to include additional offences that are sexual or indecent in nature or involve a violation of privacy, such as voyeurism or distributing intimate images without consent. And this will definitely keep the legislation relevant at this point, with the 21st century technology advancing much more rapidly than the law in this case. Mr Temporary Speaker, I'd like to ask for a small extension of time, please.
Leave granted. Yes. Well, that's a question, sorry. The question is that the member's time be extended. All of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it.
Thank you.
Member for Maitland, you may continue.
Thank you, Mr Assistant Speaker, Deputy Speaker. The victims of crime being entitled to make a statement and being able to do so in the confidence that they can have a support person present and, where appropriate, read their statement using closed-circuit television or without members of the public being present in the courtroom is very important as well. I note that the bill includes an amendment to the Criminal Procedures Act of 1986 so that domestic violence complainants in all criminal proceedings for domestic violence offences, not just apprehended domestic violence order proceedings, are entitled to have a support person present when giving evidence. And this is vital for victims and survivors because it recognises the power imbalances that are inherent in the legal system and the way that victims who have done nothing wrong are put in an environment which is quite intimidating to them and over which they feel a lack of control, which is in many cases part of the actual crime that's been perpetrated against them. Another significant initiative arising from these amendments is that the definition of the member of the primary victim's immediate family will be expanded, and this is particularly important in the areas of culturally and linguistically diverse communities, and also in our Aboriginal Torres Strait Islander communities, our First Nation people who often have more extended definitions of family and kinship, and particularly I think with the Cole community, I think that's important because often the person who may be best able to support them may have the best language skills and are able to support them may not be necessarily a member of the traditionally defined family. So that is an important thing to have as an ability for them. I support cultural inclusiveness for victims and survivors because I think it's really important that we understand and support those people who have been traumatised by violence in their world. And in situations of domestic violence, for example, I hope that those survivors will feel empowered by the knowledge that they can and will have the support that they need to challenge this totally unacceptable behaviour. While we on this side of the House don't oppose the bill, I commend it to the House. I just have to reiterate the frustration with the things that are debated in this place, and that these important steps forward for many people in our community are just being rammed through. I would have liked to have spoken on GIPAs, for example. When we've got a bill that talks about the GIPA process, Anzac memorials, victim impact statements, the jurisdictions of a small claims court, wills, all sorts of things just shoved in there together, when they actually individually have significant changes for people's lives, people who are often the most vulnerable people in our community. It indicates a lethargy of this government over the last 8 years, and I just wish that this government would pay respect to the victims and survivors of violence. It's been a huge theme within this parliament, within the community at large, over the last 4 to 5 years, and it's time that this government actually gave victims and survivors the support they need through treating the legislation which will change the way that their cases are dealt with much more respect. Thank you. Commend the bill to House.
The question is that this bill